This is Gail Brandt. I'm here today with Jim Platt for the Fredrikson Byron Health Law webinar on physician compensation. Today we're going to present an update on trends and review the reasonable compensation standards. Before we begin, I want to give you a couple quick housekeeping things. If you have any problems with the sound, please watch for instructions from Robert in the chat box. He'll be giving you a call-in number that you can use. If you have questions, please type those into the chat box. Also, our next Health Law webinar is scheduled for June 11th at noon on Wednesday, of course. And Bob Klopinski and Catherine London are going to be presenting information on the Sunshine Act, which is also now known as the Open Payments Reporting Act. And this time we're going to be talking about steps for Phase 2 reporting with a focus on what this particularly means for healthcare providers. So with that, Jim and I today are going to be talking a little bit about the trends in physician compensation. Jim will talk about nonprofit health system physician compensation, and then I'll talk about compensation for physicians in for-profit entities. We'll talk about the legal requirements pertaining to physician compensation, and then leave some time for question and answers. So with that said, Jim, take it away.
Okay, thank you, Gail, and thank you, folks, for listening to our webinar today. I'm going to start off by going over some trends that we're seeing in our office in terms of what nonprofit health systems are doing with physician compensation. And then Gail will chime in with what she's observing in some for-profit situations. And we'll turn to the legal issues and so forth. So in terms of nonprofit health system compensation, there's no question that many health systems are moving away from paying traditionally per work RVU, relative value units, or even older, a percentage of production, to different ways of compensating physicians. This is particularly true in mid to larger sized health systems, but it's even true in smaller rural hospitals. A higher percentage of compensation than has historically been the case is now being tied to quality incentives, such as patient outcomes, patient satisfaction surveys, reduction in healthcare costs, patient satisfaction. Health systems are also looking at some team incentives designed to improve the quality of care for populations and promote team accountability. But it's still the case that for most health systems, a significant portion of overall compensation is still being paid based on work RVUs. And it's also the case that for specialists in particular, continuing to pay them either on a salaried basis, production, or work RVU tends to be more common than you would see their compensation being tied to a lot of quality metrics. Health systems see this new model as ways to differentiate themselves, and in particular, ways to attract new physicians to their organizations. So you hear a lot about how these new incentives are being designed toward aligning incentives with payers and healthcare management, but it's also the case that health systems are using these to attract new recruits to their organization and attract them with new kinds of compensation models. Some examples of health system physician compensation incentives might include, of the total amount paid as compensation, maybe as little as 5%, 10%, maybe as high as 50% might be paid based on quality care incentives, with the remainder being paid based on work RVUs. And there's lots of approaches here being taken. If you were to go out and ask health systems, you'll get some health systems that will say, you know, we're looking at paying maybe 5, 6% of total pay based on incentives, and the rest is still on work RVUs. You'll see others that say, you know, we're moving toward 20% on incentives, 80% on work RVUs, and you'll see some that even are going beyond that. And when you look at the incentive portions of those compensation programs, you'll find that those incentives tend to be broken down into individual incentives and department incentives. So for example, you might have a pediatric department where 10% of the compensation for those primary care doctors is based on their work RVUs, but 10% is based on incentives. And of those incentives, maybe half of those would be based on the achievement of the pediatric department quality measures, and maybe half of those might be tied to the doctor's individual patient satisfaction measures. And in most health systems, you see the development of those departmental quality metrics bubbling up from the department themselves. Instead of others trying to figure out what they ought to be doing, many of them ask the department what sort of achievement of quality measures they would like to pursue. Other health systems, and a minority of them, but some, are looking at making far bolder moves into new compensation arrangements. For example, a health system might say, let's take 40% of your total compensation and base that on the achievement of clinic level goals. And in those setting those goals, they might look at things such as the Minnesota Health Scores website and what they're targeting, things like controlling diabetes, vascular disease, depression, cancer screening, and asthma. So tie a large chunk of compensation toward those quality metrics. Tie 10% of compensation based on the size of the individual physician's panel, the number of patients that the physician is caring for. Tie 10% of the compensation based on the size of the clinic's panel. So if you have clinics that are very busy versus those that are less busy, that impacts compensation. And tie 20% based on the number of the physician's encounters, not work RVUs, but encounters, using the number of encounters that a primary care physician had in the past 12 months times the average value of that encounter, and then put 10% based on patient experience. This is sort of, as I said, an extreme example of a health system that really went far out on the edge in terms of coming up with something that was totally unrelated to work RVUs and had a great deal to do with quality measures. In terms of then transferring those goals into compensation, and as we'll get to later, tying this into what the legal requirements are for compensation, you'll tend to see health systems starting with median market compensation. So they will take, for example, maybe 3 compensation surveys. Maybe they take the Medical Group Management Association and the American Medical Group Association, and maybe they take Sullivan and Cont'd, but they take 3 surveys. They may weight those surveys to come up with what median compensation is for a internal medicine or family practice pediatric physician. Then they will take that compensation and break that into component parts. So, for example, if median compensation is $200,000, take the $200,000 in the salary survey, allocate, a chunk of that for the quality measure, a chunk of that for the patient satisfaction measure, and a chunk of that for the size of the clinic's panel, say, for example. That way, then, you measure the performance of each incentive and then determine what compensation should be relative to that measure. So if you have median performance, if somebody hits the 50th percentile of the measure, they would receive median compensation for that incentive. If they had really poor performance, if they were below the 10th percentile of the measure, then they aren't going to get paid at all for that incentive. And if they had exceptional performance at over 90% of the measure, then you'd receive compensation above the median for that incentive. So, for example, the total compensation for a doctor, if you hit the median for each measure, right in the middle of the measure for each one of the 5, say, elements of the compensation, that would be $200,000, which is the median compensation in the surveys. If, on the other hand, a physician totally knocked it out of the park and the physician hit the 90th percentile for each of the measure, then compensation might be $320,000. So you take the median and then you move upwards from there because the performance isn't at the 50th percentile, it's at the 90th, and therefore reaching higher levels of compensation, but still tied to what the compensation surveys say up at the 75th percentile of salaries. It's interesting to do reading on this subject and see what the results are from health systems that are experimenting with these new compensation models. I would say that the results are a bit mixed. For one reason, moving away from work RVUs is still slow because most payers are still paying based on production, especially, again, as you get out into the smaller rural healthcare systems. It's only in the larger healthcare systems where we're seeing, in my experience, more of this development towards other compensation models. So it's slow. And it's also slow because physicians are unsure whether they're going to make more, whether they're going to make less, just how exactly is their compensation going to be influenced. They're coming out of the work RVU world. They're now moving into a world where they're going to be paid in a different way, and they're not sure what that's going to mean. That obviously makes communication of this pretty essential, and it makes their input essential. And to the extent a health system starts compensating physicians based on team incentives, remember the example I gave where a portion of the percentage was based on the size of the clinic's panel. 40% was based on achievement of quality measures like diabetes. Achievement of those quality measures takes a team approach. So it's not only the physician reminding patients about checking their blood pressure and et cetera, it's also the nurses and the paraprofessionals and others there all working on accomplishing these goals. And so for some, physicians, that can be a challenge. They may not be used to working in teams. So they may feel like others on the team are pulling them down, not pulling their weight. So you can see how these results are mixed, and for that reasons why areas here with health systems is moving slowly. So now I think Gail's got some comments on the for-profit world.
Thank you, Jim. The general trend that Jim discussed for, changing from a work RVU or production-based compensation model to the pay for performance is also going on in the for-profit sector. But I would say it lags even further behind some of the experimentation and trials of new methods that are going on in nonprofits. Productivity remains the predominant factor in physician group practices and for-profit employers of physicians. And compensation that's based on work RVUs performed still make up 70% or more of the compensation formulas. I looked at a number of published surveys as well as some articles and professional articles, and I found that the majority, even among groups that are adding a component of pay for performance, that generally it was only 10 to 20% of the total compensation pool, and I didn't find, I only found one for-profit that was 30%. So, it's very slow to change, and part of the reason that it's slow to change are that other factors also play into the physician compensation setting for for-profit entities or group practices. Call is a constant element of consideration with the frequency and intensity of call requirements. As we go to more hospitalist programs, call may be less onerous in some practices. Other practices have added urgency centers, Saturday and Sunday hours, as well as extended day hours, which may also create some components that are like call in the compensation formula. Again, the team orientation that Jim talked about, the use of mid-levels, other staff members, et cetera, in managing the workflow, those go into play as well. The ability to control the workflow by the physician is also an important component. Same-day clinics, for example, are changing the ability of primary care providers to control their workflow. It's not a scheduled day anymore. On the other extreme, hospital-based practices like pathology, anesthesiology, radiology have traditionally been more based on even shares or an equal share based on days of work, for example, because they don't have the ability to control what is referred to them on a particular day. The other aspect that's often considered in group formulas is some kind of component to avoid or prevent what I call cherry picking, and that's to avoid providers not taking a fair share of Medicare, Medicaid, or other lower paid or private pay patients that as compared to those that choose ones that have good commercial insurance, or to prevent cherry picking where they only want to do certain kinds of procedures or certain kinds of cases, because in most group practices you want to try to balance that out across the group. So while those factors are considered and often come into play in some component that might be equal shared or call day shared or FTE based, the majority of the compensation remains based on work RVUs, largely because third-party payer reimbursement is still predominantly based on work RVUs, as Jim commented. Those that are offering some kind of pay-for-performance strategies, it's usually less than 20% of the reimbursement. Hence, I think what I found that the groups that are paying something on pay-per-performance are doing it at 10 or 20%. And those performance measures include patient satisfaction, meeting specific targets, and meeting the goals like the community health measures. They're not necessarily targeted at the particular group practice, but more at the overall healthcare goals for the community and the health plan. As groups begin transitioning or considering transitioning to pay for performance, as it's expected to become a larger and larger component of the healthcare system, there are ways in which that is being divided. So even if we're only talking about 20% of the compensation being paid based on pay per performance, groups are splitting it up in different ways. Some are paying the amounts that are received for the performance incentives directly to the physicians who met the goal. So if you manage patients with diabetes and you've met the community measures for diabetes, you would get that portion of the incentive from the third-party payers that related to that community goal. Others are sharing amounts received for the performance incentives either equally or based on those or by FTE among the physicians that participated. So if you made the effort to meet the community standards, to do the patient satisfaction and work towards improving your goals, then you would be part of sharing of those community measures. And a common approach is to split that performance-based compensation received from the payers 50-50, half of it being shared equally for those that participated as an incentive to encourage participation in meeting those goals, and then half paid to those specific physicians that actually made the goals. So a lot of different ways in which groups are approaching this, and as any time that we change compensation or address compensation, it can cause ripples. Jim talked about the approach that's being taken by a few of the nonprofit incentives with regards to incentives and trying a broader approach, really moving away from production-based compensation. And that's also being discussed by a lot of for-profit group practices and employers. The majority of groups that are talking about it are just in the planning stages. It's very difficult to implement at this stage, particularly because of the reimbursement situation. But a number of them are really working on trying to figure out how this will work. What they're doing is designated a compensation pool that isn't necessarily limited to the funds that the group receives from performance incentives. So it might be larger than the 20% that they got from a payer that was based on performance incentives. With a for-profit entity, this is usually based on a percentage of the pool rather than a fixed amount, because they're often not working off of a set salary, for particularly for shareholders or long-term physician employees, but rather off of the available funds that can be paid as compensation. Then they establish goals that are based on the group strategy and objectives, and that may be for all of those, for all patients, not just those that are in a plan that has some pay for performance. So really what they're trying to do is design this broader kind of approach towards paying for performance. In order to do this, the goals that are set for either the individual or group performance have to be clear, measurable, attainable, and relevant. If we don't know what we're aiming at or what goal needs to be met, it's difficult to measure whether we've performed it. All of you in healthcare know that many of the existing measures for performance goals, like patient satisfaction surveys, have some serious flaws and misinformation that causes a lot of consternation in group practices and amongst physicians because they find it difficult to know how they're going to be able to change some of those outcomes or some of the measures as they're reported. Typically, when groups working on integrative approach are trying to focus on patient care and resource utilization, clinical measures, use of technology, again, patient satisfaction or other kinds of targeted actions, really trying to focus on how to be more efficient in delivering the care for their particular patient population in order to do it more efficiently. When they may establish group goals, that's the same goals for all of the physicians, and then each share if the incentive if the group meets the goals, or they may also set individual physician goals based on meeting the goals for that individual. Again, in the experimental stage and having some difficulty defining the measures, identifying the lofty goal with the population health management is pretty easy. Defining the individual goals or a group goal and then finding tools and measures that make that relevant has been difficult. Like Jim, I would say that for-profit entities' ability to shift into the pay-for-performance compensation is just too early to tell. We are working with changing individual expectations of physicians and their sense of fairness. With compensation or reimbursement still primarily work, RVU, or production-based, it's not aligned with the idea of switching to a pay-for-performance and measures kind of system. So you have physicians that perceive themselves to be penalized because they're high producers, because their patients aren't as satisfied because they didn't get to spend as much time with their physician. Just varies from situation to situation. There's also a lot of effort that's required on the part of the administrative leaders and the physician leaders to develop these plans, figure out how to measure performance, and then improve performance on sort of a continual cycle. And that requires a lot of time and effort, and obviously for physicians that need to be involved in it, it removes them from the practice. So that is another factor that makes it somewhat difficult to make these kinds of changes for profit group practices and other for-profit employers. Jim's going to switch now and talk a little bit about the laws that apply to physician compensation.
Thanks, Gail. So ticking through some of the legal issues to think about with physician compensation would include Stark, Medicare Anti-kickback, state and federal tax laws, and the False Claims Act. I should also add that if you've got questions for us, you can go into the chat box and send us questions, because when we get around toward the end of our webinar, we'd love to hear your questions and respond to those. So please send us your questions and we'll get around to those toward the end. So the Stark Law, as most of you know, prohibits an entity like a hospital from billing Medicare or Medicaid for designated health services that are referred by a physician that has some sort of a financial relationship with that hospital, unless an exception applies. And 2009, we had situations where they amended the law to say that physicians and physician-owned practices stand in the shoes of the financial relationships that their practices have with hospitals that are billing for Medicare inpatient and outpatient services. So, a pretty common arrangement we see are professional service agreements, where a group of doctors will provide services to the hospital. The doctors have a compensation arrangement with the hospital because they stand in the shoes of their professional group. Therefore, we need an exception to cover the payments that the hospital is making to that physician group for those services. Likewise, doctors who are directly employees of a health system, they have a direct compensation arrangement with the health system. They receive a paycheck, and that necessitates an exception under Stark. Stark has a number of exceptions that pertain to compensation, and these all require that compensation be consistent with fair market value. Bona fide employment, personal service arrangements, and fair market value compensation are three of them, three different exceptions that can apply to potential physician compensation arrangements with hospitals and health systems. With regard to employed doctors, so health systems that employ physicians, the Stark exception requires that the employment be for identifiable services. It also requires that the amount of the compensation be consistent with the fair market value of the services and not be determined in a manner that takes into account, directly or indirectly, the volume or value of any referrals by the doctor for designated health services. Productivity bonuses based on services personally performed by the physician are okay. And the remuneration must be provided under an agreement that would be commercially reasonable, even if no referrals were made to the employer. The Stark exception for personal service agreements, so this is the one that would pertain to, say, a professional services agreement between a hospital and a group of doctors. This exception says that the arrangement must be set out in writing, signed by the parties, and specify the services covered by the arrangement. And that arrangement needs to cover all of the services to be furnished by the physician to the entity. The services that are contracted for cannot exceed those that are reasonable and necessary for the legitimate business purposes of the arrangement. The term has to be for at least 1 year. And here again is the fair market value requirement that the compensation to be paid over the term is set in advance, does not exceed fair market value, and is not determined in a manner that takes into account the value or volume of referrals. The third Stark exception is one for fair market value, as I talked about before. And I'm not going to go into the details on that, but it's similar to the ones above. It has some additional requirements which make that one that we don't use as often as the other two I've mentioned. But as I've alluded to, the exceptions under Stark have in common the requirement of fair market value and commercial reasonableness. These are separate requirements. And we often see situations where fair market value is looked at a fair amount, but the commercial reasonableness standard gets a bit of short shrift. But they're two different requirements. Fair market value, according to Stark, means the value in arm's length transactions consistent with general market value. General market value means the price that an asset or a service would bring as the result of bona fide bargaining between well-informed buyers and sellers, here with services, who are not otherwise in a position to generate business for each other. And usually the fair market value price is the price at which bona fide sales, here for services, have been consummated for services of like type, quality, and quantity in the particular market at the time of the deal, and included in bona fide agreements with comparable terms at the time of the agreement. So you'll hear a lot in there about market, commercial reasonable, general market value. The commercial reasonableness standard says that the arrangement must make commercial sense. Why was it that a health system paid more money than it really needed to pay to get the services that it needed? Why did a health system enter into more of a space lease than it really needed to have to accomplish the legitimate commercial purposes for the organization? So here we're asking ourselves, does this make business sense? And even if there were no referrals between the parties. Now, salary surveys are without question an important element of determining fair market value. And where that comes from is in much of the commentary to the Stark regulations. CMS believes that using multiple, objective, independently published salary surveys is, in their words, a prudent practice for evaluating fair market value. They also will say, though, that good faith reliance, although relevant to the party's intent, does not establish the ultimate issue of the accuracy of the valuation figure itself, here in the context of a valuation, but still relevant. So salary surveys are a prudent practice, but they are not a safe harbor. They are not a pass. They could still be challenged, or how the salary survey was derived or how the salary survey was used may not necessarily mean that it's fair market value. And there's lots of ways salary surveys can be used and misused in determining fair market value. Ultimately, according to CMS, the appropriate method for determining fair market value is going to depend on the nature of the transaction, its location, note rural, urban may have a difference, and other factors. I should also mention, before I go to Medicare anti-kickback, that Stark, of these laws we talk about here today, Stark is particularly challenging because the Stark law is the law that says that if you have a compensation relationship with your employed doctor, as you would, or in a professional service agreement, you must fall within a Stark exception. Because if you're not within a Stark exception and you have a Stark referral relationship, it's going to be a violation of Stark unless you've met the exception. So when all of these exceptions, including employment, require fair market value, and in this world of uncertainty about what fair market value might be as we enter into this new world of compensation models, it tees up, I think, a potential for future regulation, future discussion, future issues coming as to when quality incentives and when other incentives, no longer being based on work RVUs, are still consistent with fair market value as we move forward in these new kinds of relationships. Now, Medicare anti-kickback, I'll breeze through some of these a little bit more quickly. It is like the Stark law. It prohibits payments in exchange for referrals here. And of course, Medicare anti-kickback requires an intent. So Stark is the bright line rule where you must fall within an exception. Medicare says we have very significant penalties, including criminal penalties, but there must be some intent present that there was a payment for these referrals. And under current guidelines, if even one payment, and one purpose of the payment was for referrals, that law is violated. OIG, which enforces the Medicare anti-kickback law, says that if a healthcare provider receives something of value that is not at fair market value, an inference may be made that the exchange was intended to induce referrals. So a doctor is being paid more than fair market value. You can infer from that that there may have been an intent to pay for referrals. And by fair market value, the OIG says we mean back to general commercial purposes, but fair market value has to reflect not just what you could get as you negotiate for your best possible deal, but rather it has to take into effect the fact that you can't be paying for the referrals. Medicare has some safe harbors. If you fall within a safe harbor, you are generally safe from allegations that you violated the anti-kickback law. These safe harbors are important, but if you don't fall within a safe harbor, it doesn't necessarily mean you violated the statute. It's just that you could be investigated and more scrutiny could be paid to what was going on behind the scenes. Now, it's important to note that the Medicare anti-kickback law has a safe harbor for employment, and the safe harbor is pretty simple. Amounts paid by an employer to an employee who has a bona fide employment relationship falls within a safe harbor under the anti-kickback statute. So health systems that employ physicians need to still be focused on Stark, because the Stark exception requires fair market value in employment, but anti-kickback doesn't expressly require fair market value. It does, though, require bona fide employment, and there are folks out there who make the argument, and I think they're right, that if you are paying more than fair market value, you have an issue about whether, in fact, that employment relationship was bona fide, because you're overpaying for something that you could have received for less. The anti-kickback law has a safe harbor for personal service arrangements. Again, those agreements between a hospital and a medical group where the medical group provides services and are paid for those services. And it's somewhat similar to the stark exception that I talked about earlier for personal service agreements. Now, shifting to the Internal Revenue Code, the tax laws have impacts on both the tax-exempt entities, the 501c3 and 501c4 tax-exempt health systems, and they also have implications for for-profit entities. And I'm going to tackle here for a second the tax-exempts. So the tax-exempt health systems are required to pay fair market value, because if they pay more than fair market value, then in an extreme case, the IRS could come in and disqualify the organization and tell it that it is no longer tax exempt. And that has enormous repercussions for the tax exempt health system, because they have more likely than not issued tax exempt bonds. If the health system is no longer tax exempt, it's in violation of the bond covenants where it promised that it would remain so. So maintaining the exempt organization's 501c3 status is critical. But the IRS has another tool in its toolbox where in less egregious cases the IRS can apply tax penalties called intermediate sanctions. And they can apply these to individuals who have participated in excess benefit transactions where the economic benefit was provided by an exempt organization to a disqualified person, here a physician, and the value provided exceeds the value of what was received. Now, what's helpful about the IRS rules on tax-exempt organization and physician compensation, and this is not present for the Stark and anti-kickback laws, here it's just for the tax laws, is that exempt organizations may establish a presumption that an arrangement is reasonable if we have objective third-party evidence like surveys or an independent valuation that was obtained showing that the payment was fair market value, and that those results are reviewed and approved by an outside committee made up of individuals who are not employed by the health system, like compensation committee, and that the decision is well documented. And the IRS has more detailed guidance about how this works. But this is the reason why 501c3 organizations will establish outside compensation committees or a special compensation process to ensure that the compensation they're paying gets this presumption. And that presumption would then cause the IRS to take on the burden of proof that compensation was in fact unreasonable. The health system gets a pass or a presumption that it is reasonable. And this same process, although not necessarily a pass under Stark or anti-kickback, is usually the same sort of process that's used to cover those laws as well. Because if you're going through getting objective third-party evidence like surveys, you're having them reviewed by outsiders, that sure seems to me to be a good practice across the board in all of these laws that I've talked about. And the IRS's definition of fair market value is an old one they've had around since 1959, which is the price at which property or the rights to use property would change hands between a willing buyer and a willing seller, neither being under a compulsion to buy, sell, or transfer property with knowledge of the relevant facts. So a couple concluding comments from me before shifting over to Gail is that I think we're entering into an interesting world where salary surveys historically have looked at RVUs, the number of RVUs, physician compensation, being sure that physician compensation in the surveys is not out of joint with the percentile of the RVUs. For example, if you're paying a physician at the 75th percentile compensation and the doctor is only at the 25th percentile of the work RVUs, that historically has caused people to say, why are you paying that doctor so much money when they aren't producing very much? But as we move forward and we start to pay doctors more based on incentives, you may see more of that. And so there's going to need to be further work and thought played about how to demonstrate that these incentives will end up being consistent at fair market value and how overall compensation remains at fair market value. Obviously, incentives can't be based on the volume or value of referrals. So as we think about designing these new incentives, we still have to remember that we can't be paying on the volume or value of referrals, and we can't, as Gail said earlier, pay physicians that would hurt patient care, that would reward them for cherry picking or reward them for stinting, which means not providing the necessary services that patients need. That's why compensation measures should still be tied to appropriate data, like the Medicare Shared Savings Program measures. Established quality measures that are already out there seem to be a good guidepost for people to work with. And compensation should still be tied to appropriate surveys, obviously updated when appropriate. And lastly, because things do need to be commercially reasonable, it kind of goes without saying that these measures, as I'm sure they would, need to be reasonably related to the hospital's mission and plan, that there's something that makes sense for why we wanted to pay physicians for what we're paying them for. So, Gail?
Thank you, Jim. And just a reminder that you can use the chat box to send in your questions, and we hope to have some time to do that, but we'll also respond individually if we don't get to all the questions. As you know, the Stark and anti-kickback laws that Jim has talked about apply to for-profit healthcare entities and group practices in any kind of contract or transaction between one healthcare provider and another. So he used the example of a service agreement between an independent group, a group practice, and a hospital, and that that's a good example. But any kind of relationship is going to require that those restrictions be evaluated. In addition, there is a restriction in Stark that actually reaches into the group practice and its compensation system within the group practice. So this is not necessarily in the context of a professional service arrangement with a hospital or a nonprofit entity, but every group practice where the owners, the physicians, are providing compensation. As you know, Stark has a provision that allows a group practice to bill and provide certain designated health services, DHS, as, quote, in-office ancillary services. That includes x-rays, MRIs, lab, a wide variety of services. The group practice exception also says that there's a restriction on the manner in which the group practice may pay its physicians relative to that DHS that's provided and billed for by the group. The formula by which the amount of compensation that's related to the receipt of payment for the DHS must be set in advance. That's a clear-cut first layer requirement. Second of all, the formula must not relate directly to the value or volume of the DHS referrals by a physician. So if you had a compensation system that paid a physician based on the number of MRIs he or she ordered, that would be a Stark violation. There are certain permitted formulas, however. The first one is that you could pay it on an equal or per capita or FTE basis, as long as there's at least 5 physicians in each group that you're splitting out on that sort of equal basis. The second is, it could be a group or a department for that 5 physicians. The second permitted method is to base it on the revenues or charges for the physician's personally performed professional services. These are all the non-DHS services. So if you computed a percentage of the physician, of each individual physician's personally performed services, their work RVUs for their encounters and their procedures, you could apply that to the pool of revenues based on the DHS and pay them based on that. You can divide the pool based on physician-patient encounters, or you can also divide the pool based on the work RVUs for the physicians, again, for services that are not DHS. So some specialties prefer to use just a straight production-based allocation based on personally performed service, and others prefer to use the work RVUs because the work RVUs have already been weighted for the complexity and of that particular service. So limitation on the ways in which you can allocate the revenues that you've received from DHS, and that part of your formula has to be established in advance before any revenues are received for the services and before the expenses are expended for those services. That while the tax-exempt and intermediate sanction laws that Jim talked about that apply to nonprofits don't apply in a for-profit entity, and we generally think that a for-profit entity can pay whatever compensation it's able to pay, there are limitations, and that is called excess compensation in the for-profit world. A for-profit entity is permitted to deduct a reasonable amount for salaries and other compensation for personal services rendered, and if compensation is paid in excess of reasonable compensation, the IRS treats that excess as a dividend. In C corporations, that means that it would be taxed at the corporate level before it's distributed to the physicians or shareholders, and then taxed again at the shareholder level. So this is an important consideration because that is obviously a very heavy tax hit in the 70s, maybe even higher percentage of the amount that would be available for distribution going to taxes rather than to the individual shareholders. Reasonable compensation has a facts and circumstance test. It is based on employee qualifications, prevailing rates of compensation for similar positions, comparison of the compensation paid by other companies for the similar services, the salary policies of the taxpayers, the internal consistency, and the character and condition of the company. That's the financial condition of the company. It's also got to be a free bargain between the employer and the individual made before the services are rendered. So this is an important component for your employment agreements with physicians to provide for the comp that's going to be paid. Even though it may just reference a compensation formula, that's important that you include that in your physician employment agreements. Those amounts are generally allowed as deductions by the IRS, even if it exceeds the amount that would ordinarily be paid. Ironically, however, because it's a facts and circumstance test, it's been an interesting part of the tax code in its interpretation by the Internal Revenue Service. And has kind of ebbed and flowed in terms of enforcement over the last 50 years. In the early 1990s, there was a case pediatric group practice in Texas, for which the service disallowed the amounts of compensation paid to the physicians for the overages, if you will, the excess profits for the nurse practitioners that were employed by the practice. That case was not well followed. It had a lot of issues in the analysis, and it wasn't a binding or holding in other jurisdictions. Nonetheless, we saw a lot of organizations that evaluated, and those that could convert to S corporations or choose another form did, and more attention we paid to how those amounts were paid, with emphasis on how the compensation formula was written. These elements, excess compensation has arisen again. We need more money in our tax coffers, so there's more zealous enforcement in certain areas. And executive compensation and large compensation was first targeted with regards to excess compensation, but we're also seeing it being applied in other high-income taxpayers, including physicians. One of the things that are hot buttons that cause some scrutiny for the IRS is that statement that the deduction is available for compensation for services rendered. And as a result, the agency, the IRS, has been looking more at ancillary services, profits or amounts that are received for other kinds of things rather than the services directly rendered by the physicians as potential dividends, and also revenues from services performed by other practitioners, much like that pediatric case in Texas of 20 years ago. Other avenues are also investments that you might have in other ventures and how those flow through the group practice or the tax-paying entity. The other factor that invites scrutiny is not paying dividends, but it is not the only reason that the IRS will disallow salary deductions. But it can be taken as a factor in the facts and circumstance test. It's important to keep track of the things that you do to invest in your private practice. The purchase of equipment, etc., is kind of easy to track, but you should also be tracking the investments that you make in the training of staff and physicians, the recruitment costs for staff, providers, etc., because all of those can weigh into showing that the profits of the company have actually been paid back into or put back into work in the group practice. It's important also to consider that this excess compensation is not in itself creating an issue for S-corps or LLCs, because they're just taxed at the individual taxpayer level rather than at the corporation. But be aware that reasonable compensation can still be an issue for these entities but it switches hats. The issue then becomes whether you've taken too much as distributions, thereby avoiding the payment of FICA and Medicare taxes, as opposed to the dividend issue. So it's important that you keep a balance between compensation and distributions in S corporations and LLCs as well. How do these rules reconcile with the trends that we're seeing as we look at for-profit entities? Be sure to emphasize physician involvement in patient care when you're developing your compensation, even if it's not based on production. So physician involvement, for example, in the supervision and development of nurse practitioners or physician's assistants is important when you're considering that any overages might be paid to physicians. Similarly, if you're looking at using other performance measures, emphasize as you write things up that physician involvement in that decision making. Base the allocations on services that were performed, the actual supervision or the actual provision of the professional services. And as I described for certain ancillary services under the ancillary services exception for group practices, DHS has to be allocated either by professional services or per capita, etc. Benchmark your total compensation against survey data. Unlike the nonprofit sector that Jim talked about, you don't have an obligation to really base your compensation in a for-profit entity on survey data or fair market value, but you need to be aware of where you come out against the surveys, because if you're negotiating with a nonprofit entity, you're going to need to know that information to be able to balance and come up with something that's workable for both parties. If you're dealing with the IRS, they're going to go look at survey data and try to come up with benchmarks. So you want to take a look at where you fit within those benchmarks. Be sure that your salary formula is set in advance and in writing, and always make changes prospectively, not retrospectively. One of the interesting things is I think our practice is to recommend salary formulas for group practice be in minutes rather than necessarily in the employment agreements for individual physicians, but the employment agreement should be sure that it references that compensation formula so that if it's looked at, you can point to it and incorporate it in that document. And I think that's common practice, but it's important to be mindful of it. I'd also encourage you to avoid using words like distributions and distributable income, words that necessarily imply a dividend, because those are the kinds of things that just invite scrutiny from the IRS. None of these things should inhibit or impair moving towards pay for performance or using other compensation markers. These are more with regards to how the formula is set up and administered than it is the individual elements within the formula. Jim, I think we're at the point that we are going to take some questions, and I think you have a couple already.
Yeah, sure. Thanks, Gail. So in the few minutes we have left, let's tick through some of the questions you sent us. So question, how should we determine fair market value for physicians? Is there a resource? Yes, I have several suggestions. First of all, you can obviously go online and search for physician salary surveys, and you'll get a bunch. But the American Group Practice Association, the Medical Group Management Association, Sullivan and Cont'd, there's other organizations that publish physician compensation surveys, and you can purchase those. They are pricey, but that is where most of the physician survey data comes from. The other thing you can do is you can retain a compensation consultant. The compensation consultant may have other resources, based on their experience in the industry and their knowledge of what other people are doing. They may be able to give you some ideas, and ultimately with a compensation consultant, the idea is for the consultant to give a letter that says that they believe that the compensation is consistent with fair market value. So compensation consultants. The third thing, and this is out of the IRS rulings, is that offers made by other competitors in the market, what others in the market are doing, and if you've got data about what other health systems are offering physicians, say for new employment or bringing in somebody for another group, that is helpful in showing what fair market value is. Although what other organizations pay isn't always completely a pass, because everybody may be paying perhaps too much. So it may not be as good as the first two, but there are some ideas. Next question I got, and I'll just do mine and I'll turn them over to Gail. How does the Stark Law apply to hospitalists? Well, it does apply to hospitalists because they are physicians. It is worth noting that Stark, when I talk about physicians, it doesn't define physicians quite the way you think it would, and it doesn't define referral quite the way you think it would. They're broader. Physicians are defined to include more than just MDs. For example, they include podiatrists, they include oral surgeons, they include chiropractors. So, it's more than just medical doctors. And so it does apply to hospitalists. And referral is more than what you would think. A referral includes anything that the hospital would provide, so inpatient and outpatient hospital services and imaging that would be part of a patient's plan of care. So it's not necessarily that the doctor says to me, Jim, you need to go over to XYZ hospital. It may be because that in my plan of care, the hospitalist has designated certain kinds of hospital services that are going to be provided to me, or that they're going to be part of what the hospitalist is recommending and developing. So it does apply. And last question I had was, do the results of a fair market value analysis of physicians who are contracted with the hospital need to be presented to the board of directors when the hospital is nonprofit? If so, how much detail? This is a pretty common problem or challenge with rural hospitals. Yes, I do believe that the results of the fair market value analysis does need to be reported to the board. What I like to do is to use a compensation committee. So you've got maybe 3 outside directors of the board who sit on the comp committee. Management then presents to that comp committee survey data, what others are paying, what a comp consultant has advised them about, what the salary surveys say. And I've had organizations, if they say, gee, we're afraid that Doc Jones's salary is going to be known by everyone in town because of who's on our comp committee. I've had situations where they've blinded the results. They haven't put Dr. Jones's name down and what he's being paid. They call it Dr. A, or they blind them in some fashion. And I think that's fine. As long as the comp committee and the board can get some assurance and documentation that it's fair market value, I do think that's a prudent practice. So, Gail?
Thank you. The first question that I'm going to answer is, we use the MGMA as a survey resource regarding provider compensation. What other resources do you recommend? Jim has mentioned in his talk the AGMA survey, the Sullivan-Cotter survey. Those are both good surveys. Most group practices like the MGMA because it's private practices that provide the data for MGMA. And as Jim said, there's a host of compensation consultants that are also developing various resources. The next question that I'm going to answer is DHS only from Medicare and Medicaid payments, or is it all collections from services such as X-ray lab, et cetera, or designated health services? First of all, I'm going to expand it. Is it DHS only from Medicare, Medicaid, and governmental payers? And Stark explicitly applies to those payments. So with regards to the Stark rule that I talked about, those are the governmental payers. In Minnesota, however, we have what we call a RAP statute that incorporates the anti-kickback provisions to all payers. So in Minnesota, and this will vary from state to state depending on whether they have a similar statute, as Jim explained, the fair market value requirement for bona fide employees is not required. It's there's a safe harbor in the anti-kickback statute for bona fide employees, and you don't have to meet that fair market value requirement. So theoretically, you could pay for the DHS or ancillary services for other payers. But we also have to remember, as Jim described, that sometimes then the employment relationship can be called into question as to whether it's bona fide employment, and also whether or not there is a referral within the group for that. The best practice in Minnesota is generally to include all of the ancillary service revenues, all of the DHS revenues in the allocation, and use one of those methods that would be permitted under Stark, because that gives you some security that the method that you've used will be okay. Next question is, do you have suggestions for changing physician compensation from straight salary to part of the compensation being at risk? Anytime we change compensation systems or formulas, there are winners and losers. People feel very threatened that their salary will be changed and how the incentives go. So the first thing that I would recommend is that the group or the leadership have an understanding of what the objectives are for making that change. In a large system, you're going to probably do that by committee. It needs to be sure that it includes a broad enough representation of physician leaders to have it trickle down and be accepted by a larger group, by your larger group of physician employees. In a smaller or in a group practice, even a larger group, independent group practice, you want to probably start with the whole group, possibly using a compensation consultant or at least a facilitator to decide on those goals that you're going to try to accomplish, and then have a subcommittee that works on making those recommendations for approval by the group. It is not a quick or process. It takes a lot of effort and a lot of physician leadership as well as administrative leadership to work through it. My other recommendation is to start with some of the baby steps, those kinds of things that we are seeing groups do where they're essentially passing through or implementing within their own compensation systems those parts of pay for performance that are being paid by the health plans, so that they can have a mechanism for doing that. Last question that I have time for, and then I think we're pretty much out of time, is if a physician, an employed physician, receives compensation for ancillary services, lab and x-ray, is volume-based, is this considered the same as payment for referrals? As I described in the slide with regards to the group practice exception, even if it's bona fide employment, particularly if you're relying on the group practice exception, that if you're going to receive compensation for ancillary services, it should not be directly tied to the referral or the order for that ancillary service. Using any of the methods that we described would work, and in a nonprofit setting, you always have to check back against the fair market value standards, because you couldn't pay in excess of fair market value just because it was based on, for example, referrals for MRIs or some other services. So that's always the kind of the litmus test. Using the methods that I described that are permitted under Stark work well in the other settings, as long as you make sure that overall compensation still fits within that fair market value standard. Jim, thank you for...
Thank you for everybody listening in today. And our next webinar, Gail,
is June 11th, and it's going to be on the Sunshine Act and its Phase 2 implications for providers.
Okay, great. Well, we look forward to having you folks sign up for our next webinar in June. Thanks a lot.
Thank you.